Academy, and today we are in the series of actually that is called Punjab Crash Course, and in that we will be seeing the East Punjab Rent Control Act, right? Rent Restriction Act, and that is of the year 1949. And I would like to keep some aspects which are important from the purview that how this act came into existence. And the first and foremost thing, that is the year 1939, that has to be brought to your notice. Now this was the year actually of World War II. World War II आके यहाँ पे ये हुआ था, and the government, actually the government which was ruling India was the British government. Now British government was in a strong need of that is called finance. It's needed some sort of financial assistance for running the government, and that is why they brought that is called the Punjab Rent Act. इन्होंने लाया, ठीक है. Now Rent Act, that was of the year I think 41, right? Sorry. It was Punjab Urban Immovable Property Tax Act of 1914, right? Second World War was in the year 1939. It was the year 40 that has seen Urban Immovable Property Tax Act. और इस टैक्स एक्ट के इमूवेबल प्रॉपर्टी पे जब टैक्स लगाया, now it led to a panic situation on the one who were the actual holders of that property and who had to pay a huge amount of tax. Now there came the situation of something that is like a baffling state among the tenants, and that is the occupier or the landlord, right? Now this brought actually a panic situation, right? And British government enacted that is the Punjab Rent Restriction Act of 1941 to control actually that situation. And further, now the India got divided into two states, that is Pakistan and that is India. Divide ho gaya, and after division the west part went to the that is called Pakistan, and east part actually remained with the India, and that is why you will find the word East in the Punjab Rent Control or Rent Restriction Act, right? So that all that aspect we will be seeing from the beginning. As the word rent suggests, it can easily be construed that any rent law is a law that is used as a tool to control. Now this is the tool, this is the mechanism actually. This is a mechanism actually, right? To control and regulate. Two words are very important here. One is to control and the other one is to regulate the relationship of, and to also adjudicate. Now what is this word adjudicate? Adjudicate means to decide. It is to decide the disputes arising between that is called landlord and the tenant. So this act is basically to control, regulate and to decide if any dispute arises between the two, that is landlord and the tenant. The next aspect, that is the historical background की जब हम बात करते हैं, तो rent legislation in the erstwhile state of Punjab relates back to the time of Second World War, and that is the year 1939 is the remarkable year here, right? 1939. Now the World War had led actually to a huge amount of losses, which started in the year 1939 when various taxes were imposed by the British government to set off the cost of the war. War होता है तो बहुत ज़्यादा खर्च होता है, और खर्च होता है तो सरकार को रेवेन्यू चाहिए. नाउ दे डिसाइडेड, इस वॉर के अंडर में इनको जो वो कॉस्ट बियर करना पड़ रहा था, तो उन्होंने नया नया तरीका फॉर्मुलेट किया कि जैसे रेवेन्यू जनरेट किया जा सके, राइट? एंड द प्रोविजंस ऑफ पंजाब अर्बन इमूवेबल प्रॉपर्टी एक्ट Tax Act was brought in the year 1940. The effect of imposition of this new tax on the urban property led to a steep rise in rents of the property. अब चूंकि प्रॉपर्टी पे टैक्स लग गया तो लैंडलॉर्ड कहता है कि तुम पे करो, या लैंडलॉर्ड कहेगा कि भाई आपका जो रेंट है वो बढ़ गया है क्योंकि हमें अब क्या देना है, सरकार को टैक्स देना है. प्रैक्टिकली अगर हम बात करें, प्रैक्टिकली तो दिल्ली में आपने जब पानी पे बिल लगने लगा, इलेक्ट्रिसिटी का कॉस्ट बढ़ गया, तो वो अल्टीमेटली किससे मांगा जाता है? आप सोच के देखो, दे आर ऑल ट्राई टू बी कलेक्टेड फ्रॉम द रेंटर्स. एक्चुअली जो इन्होंने रेंट लिया हुआ इस प्रॉपर्टी को, उसी से कलेक्ट करने की टेंडेंसी रहती है लैंडलॉर्ड्स की. आप रहे, हम रहे, सबका यही एस्पेक्ट रहता है, राइट? कि चूंकि तुम मेरे प्रीमाइस में रेंटर हो एंड यू आर ऑल्सो वन ऑफ द पार्ट, तुम भी यूज कर रहे हो, नाउ यू पे द बिल्स. लैंडलॉर्ड की टेंडेंसी होती है कि मैक्सिमम टू मैक्सिमम वहां से ग्रैब कर लिया जाए. नाउ दैट सिचुएशन लेड टू डिस्प्यूट्स बिटवीन द दैट कॉल्ड टेनेंट एंड द लैंडलॉर्ड, राइट? The effect of imposition of these new tax on the urban property led to a steep rise in the rents of the property in the concerned area, which further led to the various landlords getting their rented accommodation vacated. अब इसका पैनिक क्या हुआ कि सारे लोग क्या करने लगे, भाई इतना हम नहीं दे पाएंगे. They started vacating the premises for letting it out fresh on a higher rent. या तो तुम नया वाला रेंट पे करो या तो फिर प्रीमाइस खाली कर दो. ऑप्शन भाई किसी को हुआ कि भाई मैं पे कर दूंगा तो वो रह गया, और जिसने कहा कि नहीं हम तो नहीं पे कर पाएंगे भाई तो खाली कर दो, कोई बात नहीं. इन ऑर्डर टू कंट्रोल द सेट सिचुएशन एंड ऑल्सो अवॉइड द शॉर्टेज ऑफ अकोमोडेशन, द ब्रिटिश गवर्नमेंट इनैक्टेड द वेरी फेमस एक्ट, दैट इज पंजाब रेंट रेस्ट्रिक्शन एक्ट ऑफ 1941. The object and purpose of the said act was to ensure that the rent was not increased unduly by the landlords. अब टैक्स के नाम पे इन्होंने क्या किया कि प्रॉपर्टी जो रेंट की जानी है, नाउ दे स्टार्टेड कलेक्टिंग ह्यूज अमाउंट. नाउ दैट टू नीडेड टू बी कंट्रोल, कि एक पैनिक सिचुएशन ना बने, एक वेल वर्स्ड सिचुएशन रहे, एक वेल बैलेंस सिचुएशन रहे. नाउ दे ब्रॉट एन एक्ट, राइट? The said act came into force initially for a period of how many years? 5 years. However, the same could be extended further by a resolution of the State Assembly. The rate of rent as in the act was chosen to be the rent of existing on 1/1/1939 or the rate on which the properties were first let out. तो either of them, या तो उससे पहले से जिस डेट पे रेंट हुआ था उस डेट पे जो रेंट रहेगा वही रहेगा, या 1/1/39 को जो रेंट था वो रहेगा, राइट? नाउ दे टू हैड द ऑप्शन. देयर वाज ए क्लियर एम्बार्गो इन द सेड एक्ट whereby the rent could only be increased if the landlord provided extra amenities. अगर तुम बढ़ा रहे हो रेंट, now you will have to increase the amenities, you have to increase the facilities, right? At his own expense to the tenant. Any amount in excess of the such rent, if taken by the landlord, could be legally recovered back by the tenant. तो अगर कोई एक्स्ट्रा लिया है तो वो इनको क्या करना पड़ेगा, रिटर्न करना पड़ेगा, एंड दैट टू विल बी डन बाय द प्रोसेस ऑफ लॉ. रिकवरी किया जा सकता है जो अगर उन्होंने एक्सेस अमाउंट कोई भी ले लिया है तो, राइट? यहां तक मेरे साथ. Coming to the next aspect, the said act was although to remain in force for a period of 5 years. But however, it was extended further and continued to operate till the time it was replaced by the Punjab Urban Rent Restriction Act of 1947. The said act introduced the concept of two very important aspects, and that is called controller, and the second one that is called appellate authority. कंट्रोलर और एपिलेट अथॉरिटी का कॉन्सेप्ट दिया इस एक्ट ने, एंड द एक्ट इज पंजाब अर्बन रेंट रेस्ट्रिक्शन एक्ट ऑफ 1947. जुडिशियल अथॉरिटीज टू एडमिनिस्टर द एक्ट एंड वाज मेड एप्लीकेबल टू द इंटायर प्रोविंस. इंटायर प्रोविंस कहने का यहां मतलब है होल ऑफ द पंजाब, वेदर बी इट वेस्ट पंजाब और ईस्ट पंजाब, राइट? कमिंग टू द नेक्स्ट एस्पेक्ट, इन दिस न्यू इनैक्टमेंट, grounds of ejectment. Now what is this ejectment? Ejectment कहने का मतलब है eviction, evict कराना, premise को खाली कराना, right? Am I audible, Ria? Please type Y in the chat box if it is audible to you. Good afternoon. Good afternoon. Is it audible? Okay. So we are dealing actually, that is called Punjab East Punjab Rent Restriction Act, right? And I have started some aspect, वो आप उसको recording से cover कर लेना, ठीक है? I will be taking it right from here. Introductory ही था, I will recap it, ठीक है? We are seeing East Punjab Rent Restriction Law of 1949. Before that, we have to understand the historical aspect. Historical aspect की जब मैं बात करता हूँ, 1939 was the time when the World War actually happened, Second World War, right? Now, World War के financial crisis को meet करने के लिए, to meet the financial crisis, the British government of that time, imposed some sort of, that is called property tax. That is basically immovable property tax को इन्होंने impose किया. To meet that financial crisis, they imposed, British government ने impose किया property tax, immovable property tax. अब इस property tax का situation ये हुआ कि जैसे ही, as soon as they imposed this property tax, now this led to a panic situation. The landlord started to increase the rents of the property, increase the rents of the property of the tenants, right? Now, and this led to a panic situation. Now the landlords claimed that either you pay the new amount or you vacate the premises. Either you pay the amount or vacate the premises. Now this was a very panic situation actually, and to control that, the British government of that time brought, that is called Punjab Rent Restriction Act. Rent Restriction Act इन्होंने लाया to control that, and they said that effective that date, that is 1/1/39 or earlier one, on this date, what was the rent? Now that will be the rent you will have to collect from the renters, that is tenants, right? You cannot increase the same. You cannot increase the same. And if you are increasing the rent, then you will have to provide some sort of amenities at your own expense. Now landlord at his own expense will be providing extra amenities if he is bound to increase the rent, right? So this is how Punjab Rent Restriction Act actually came. And this was brought actually for the period of 5 years. हालांकि this was subject to be reviewed from time to time. इसके time period को बढ़ाया जा सकता था. Provision was there, right? Now from here you will be collecting the aspect from the notes. Is it visible to you? Visible है? Yes. As the word rent suggests, it can easily be construed that any rent law is a law that is used as a tool to control and regulate the relationship and also adjudicate the disputes arising between them. Now, tool कहने का मतलब है, it insists on the word that is called mechanism. एक तरीका, right? कंट्रोल करने का और रेगुलेट करने का, किस चीज को? The very relationship. And adjudicate कहने का मतलब है to decide the dispute arising between them, landlord and the tenant. So this was basically to control the relationship of landlord and tenant, right? The historical background of the rent legislation in the erstwhile state of Punjab relates back to the time of Second World War, which started in the year 1939, when various taxes were imposed by the British government to set off the cost of the war. वर्ल्ड वार टू ने मतलब बहुत ज़्यादा ही डिवास्टेशन लाया था, एंड ब्रिटिशर्स वेर वन ऑफ द लीडिंग रोल जिसे कहा जाता है प्ले करने में, और इनका भी काफ़ी खर्च हुआ था, और उस समय पे इनके बहुत सारे कंट्रोल में थे, बहुत सारे एरियाज पे इनका कंट्रोल था. सो दे हैव टू पे ए ह्यूज अमाउंट टू मीट दैट वॉर सिचुएशन, राइट? So to get back, to generate revenue, now they applied various minds, and there was one such was the law they have brought in the form of urban immovable property tax of 1940. The effect of imposition of this new tax on the urban property led to a steep rise in rents of the property in the concerned area, which further led to the various landlords getting their rented accommodation vacated. तो बड़ी साफ तौर पे उन्होंने कह दिया कि या तो नया वाला रेंट पे करो या फिर प्रीमाइस को मेरे खाली कर दो, राइट? फॉर लेटिंग इट आउट फ्रेश ऑन हायर रेंट. Now this matter came to the notice of the government at that time, British government, and in order to control the said situation and also to avoid the shortage of accommodation, the British government enacted the Punjab Rent Restriction Act of 1941. The object and purpose of the said act was to ensure that rent was not increased unduly by the landlords. Now this act लाने का पर्पस यही था कि अनड्यू अनहार्श जो रेंट प्रॉपर्टी का जो रेंट है वो ना बढ़ा दिया जाए, टू कंट्रोल में रहे, इसलिए इन्होंने लाया द पंजाब रेंट रेस्ट्रिक्शन एक्ट ऑफ 1941. द ऑब्जेक्ट एंड पर्पस ऑफ द सेड एक्ट वाज टू इंश्योर दैट rent was not increased unduly by the landlords. The said act came into force initially for a period of how many years? 5 years, right? और उसके बाद however the same could be extended further by a resolution of the state assembly. The rate of rent as in the act was chosen to be the rent existing on the markable date is 1/1/39 or the rate on which the properties were first let out. तो दोनों में से जो पहले होगा दैट डेट का रेंट ही इफेक्टिव होगा, एंड दिस वाज सेट इन दिस एक्ट, दैट इज पंजाब रेंट रेस्ट्रिक्शन एक्ट ऑफ 1941. नाउ द नेक्स्ट एस्पेक्ट इज देयर वाज ए क्लियर एम्बार्गो इन द सेड एक्ट वेयर बाय द रेंट कुड ओनली बी इंक्रीज्ड इफ द लैंडलॉर्ड प्रोवाइडेड एक्स्ट्रा अमेनिटीज. हालांकि दे क्लॉज में ये बात भी इन्होंने डाली कि अगर आप अपना रेंट बढ़ाना चाहते हो, नाउ दैट फॉर दैट यू विल हैव टू प्रोवाइड एक्स्ट्रा फैसिलिटीज, एक्स्ट्रा अमेनिटीज टू द दैट इज कॉल्ड टेनेंट, एंड दैट टू एट योर ओन कॉस्ट, राइट? सो एट हिज ओन एक्सपेंस टू द टेनेंट. एनी अमाउंट इन एक्सेस ऑफ द सच रेंट इफ टेकन बाय द लैंडलॉर्ड could be legally recovered by the tenant. So the tenant can file very well a suit for recovery of the amount which has been taken in excess, right? यहां तक मेरे साथ? यहां तक डन है? प्लीज जस्ट टाइप Y for yes. डाउट हो तो D. Thank you. The said act was although to remain in force for a period of 5 years, but however it was extended further and continued to operate till the time it was replaced by the Punjab Urban Rent Restriction Act of 1947. Now 1947 is the remarkable year. इस एक्ट का नाम क्या है? It is Punjab, the Punjab Urban Rent Restriction Act of 1947. Now this was the year India and Pakistan got divided. The west part of the Punjab province went to the Pakistan side, and the east part of the Punjab province remained with India. Now that is the technicality क्यों इस एक्ट का नाम ईस्ट पंजाब पड़ा? ठीक है, इसके पीछे का रीजन यही है. द सेड एक्ट इंट्रोड्यूस द कॉन्सेप्ट ऑफ कंट्रोलर एंड अपीलेट अथॉरिटी. सो कंट्रोलर और अपीलेट अथॉरिटी का कॉन्सेप्ट कहां से आया? सो इट केम विद द पंजाब अर्बन रेंट रेस्ट्रिक्शन एक्ट ऑफ 1947, right? Judicial authorities to administer the act and was made applicable to the entire province. In this new enactment, grounds of ejectment, ejectment कहने का मतलब है कि उसे evict कराना, खाली कराना, right? Tenant को बाहर करना. Ejectment were introduced whereby the landlord could seek the ejectment of the tenant from the demised premises only on such grounds. Now the grounds were clearly mentioned therein, on what sort of ground you can keep the tenant out of that premise, खाली करा सकते हो, ठीक है, and no other. तो जो grounds दिए हैं उसी ground पे, there can be personal ground, there can be some other grounds, right? So that we will be seeing. Concept of fair rent was also introduced. Further many provisions of code of civil procedure, जैसे कि आपका execution हुआ, ये सब भी इस पे एप्लीकेबल बनाया गया. एंड वे आर मेड एप्लीकेबल फॉर द पर्पस ऑफ समनिंग ऑफ विटनेसेस एंड एक्सिक्यूशन ऑफ ऑर्डर. एनी वायलेशन ऑफ दीज प्रोविजंस वाज मेड पनिशेबल अंडर सेक्शन 19 ऑफ द सेड एक्ट. नाउ पेनाल्टीज का कॉन्सेप्ट भी सेक्शन 19 में देखने को मिला. After the partition of the country in 1947, the part of Punjab that remained in India was popularly called East Punjab. And in those days, as a result of 1947 Rent Act was replaced by the East Punjab Rent Restriction Act of 1949. So this is how the name East Punjab actually came to concept. The said act was a complete legislation in itself, whereby it is not only defined the concept of landlord and tenant, but also classified the buildings into three categories. That is residential, non-residential and scheduled buildings, apart from a separate category of rented land. It further laid down the exhaustive procedure for protection of tenants from unscrupulous landlords, but also laid down detailed and exhaustive ground under section 13, whereby the landlord could seek the eviction of tenant. So it is not that all the time tenants will only be protected, rather it is the rights of the landlord that too has been made protected by this act, right? Whereby the landlord could seek the eviction of his tenant. The ground specified therein were like areas of rent, subletting. ठीक है, सबलेटिंग. सबलेटिंग कहने का मतलब है कि मैंने आपको लिट किया और आपने किसी और को लिट कर दिया. दैट इज कॉल्ड सबलेटिंग, राइट? एंड मटेरियल अल्टरेशन सो एज टू अफेक्ट द वैल्यू एंड यूटिलिटी ऑफ प्रीमाइस. अब आप कुछ उसमें मटेरियल अल्टरेशन कर रहे हो, तोड़ ताड़ कर रहे हो. स्क्रीन क्लियर नहीं है? आई शुड इनलार्ज इट. नाउ इज इट विजिबल प्रॉपरली? अब सही है? नो? ओके, जस्ट ए मिनट. इज इट विजिबल रिया? अभी कुछ विजिबल है? लाइटली बेयर कर पाओगी? आई विल बी रीड. ओके ओके ओके, चलो कोई नहीं, लेट अस कंप्लीट. So where like areas of rent, subletting, material alterations so as to affect the value and utility of the premise. कहने का मतलब है कि such material changes that you have made to the premise, that is decreasing the value, that is decreasing the value of that property, or changing the structure of the property internally can be a ground for eviction. एविक्ट कराया जा सकता है, इजेक्ट किया जा सकता है. गॉट द एस्पेक्ट राइट? सो इजेक्टिंग. नाउ वैल्यू एंड यूटिलिटी ऑफ द प्रीमाइस. न्यूसेंस करते हो तो क्या खाली करा सकता है लैंडलॉर्ड? टेनेंट सीजिंग टू ऑक्यूपाई एंड पर्सनल नेसेसिटी ऑफ द लैंडलॉर्ड. नाउ दीज आर द ग्राउंड्स ऑन विच बेसिस द लैंडलॉर्ड कैन वेरी वेल आस्क फॉर ejecting the tenant, right? So these have the grounds. The East Punjab Urban Rent Restriction Act 1949 prior to 1956 permitted a landlord to evict his tenant from a non-residential building on the ground of bona fide requirement for his own use. However, the said right of the landlord was taken away by the East Punjab Urban Rent Restriction Amendment Act of 1946. 1956 में एक amendment लाया गया by which the rights of the landlord to get the tenant evicted from the premise, get the tenant ejected from the premise actually was snatched, and the grounds were made very restricted for eviction. evict कराने का, eject कराने का बहुत ground restrict कर दिया गया, right? The amendment which came into force on 24th of September 1956, the relevant provisions of the act are section 13 में changes किए गए थे which deals with the eviction of tenants. इसका topic है A landlord may apply to controller for an order directing the tenant to put the landlord in possession. तो possession में back लाने के लिए petition लाया जा सकता है. Before whom? It is the controller, right? In case of a non-residential building or rented land, he requires it for his own use. He is not occupying in the urban area concerned for the purpose of his business any other building. Now the point is if he is possessing any other building in that urban area, now it will be hard for him to get that portion evicted or ejected. वो tenant को फिर हटाना उसके लिए मुश्किल हो जाएगा. And as the case may be, has not vacated such a building or rented land without sufficient cause after the commencement of this act in the urban area concerned. So this was actually the amendment they have brought. The amendment was enforced by the notification from 24th of September 1956. The relevant provisions of the amendment are as under. Amendment ने क्या changes लाया? Short title. This act may be called East Punjab Urban Rent Restriction Amendment Act of 1956. Amendment of section 13 of the East Punjab Act number 3 of 1949 in clause A of subsection 3 of section 13 of the East Punjab Urban Rent Restriction Act, hereinafter referred to as Principal Act. Subclause A, 2 के subclause A में the word a non-residential building or shall be omitted. Now this was non-residential building को ही हटा दिया गया. Residential है तो खाली कराओगे, non-residential है तो खाली नहीं कराओगे. In sub paragraph B, the words building or and the words as the case may be shall be omitted. Now these were the amendments that were brought actually, right? In sub para C, the words a building or shall be omitted. तो ये सारे aspects change किए गए थे section 13 के. In subclause 4, for the words any building where they first occur, the words any residential building shall be substituted. So जो लैंडलॉर्ड था उसका राइट बहुत ज्यादा रेस्ट्रिक्ट कर दिया गया. इट बिकेम वेरी रेस्ट्रिक्टेड एंड इट वाज जस्ट ब्रॉट टू द रेसिडेंशियल बिल्डिंग्स ओनली. अगर नॉन रेसिडेंशियल बिल्डिंग है, अगर वो कमर्शियल बिल्डिंग है और आपके पास अर्बन एरिया में कोई दूसरा कमर्शियल बिल्डिंग है, नाउ इट विल बी वेरी हार्ड फॉर यू टू गेट द टेनेंट एविक्टेड और इजेक्टेड, राइट? ही विल रिमेन देयर सिंस यू डू नॉट हैव. इस अमेंडमेंट ने वो सारे राइट्स क्या कर लिए? एक लैंडलॉर्ड के राइट्स को बहुत ज्यादा रेस्ट्रिक्ट कर दिए. In the second proviso for the word a residential, a scheduled or non-residential building, the rented land, the words a residential building or rented land shall be substituted. तो इसने जो पावर स्नैच कर लिया लैंडलॉर्ड का, that was for scheduled building and that was for non-residential building. वो एविक्शन का रोल कहां तक प्ले कर सकता था? That was still only till residential building. Okay. So, after the enforcement of the amendment, the provisions of the act are as under. A landlord may apply to controller for an order directing the tenant to put the landlord in possession in case of rented land if he requires for his own use, he is not occupying in the urban area concerned for the purpose of his business any other rented land. अगर उसके पास कोई और रेंटेड लैंड नहीं है तो फिर खाली कराना मुश्किल हो जाएगा. हैज नॉट वेकेटेड सच रेंटेड लैंड विदाउट सफिशिएंट कॉज आफ्टर द कमेंसमेंट ऑफ दिस एक्ट इन द अर्बन एरिया कंसर्न. ठीक है, अब क्लियर है रिया? इज इट क्लियर नाउ? It is clear? Okay, okay. यहां तक डन है? यहां तक डन है? यहां तक कोई डाउट? चलो फिर ठीक. Okay. Now this was definitely challenged before the Supreme Court. A bare perusal of the above mentioned amendment and unamended provisions will be revealed that prior to the coming into force of the amendment, a landlord could seek eviction of his tenants from a non-residential building for his own bona fide requirements. But the said amendment, the very important line, but the said amendment had taken away the said right of the landlord. बहुत ज्यादा रेस्ट्रिक्ट नहीं कर दिया कि तुम खाली ही नहीं करा पाओगे. एक तरह से अगर दूसरा बिल्डिंग है तुम नहीं खाली करा सकते. थिंक अबाउट इट, राइट? Now this was challenged before Honorable Supreme Court of India and it remarkable landmark judgment है. एक तरह से आप इसको जरूर देखेंगे. The constitutional validity of the said amendment was challenged in the case of Harbilas Rai Bansal versus State of Punjab and another, and its judgment is of 1996, whereby the Supreme Court, while relying upon its earlier constitution bench judgment in Gyan Devi Anand versus Jeevan Kumar and others 1985 volume 2 Supreme Court cases, had struck down the said amendment. क्या किया था? अमेंडमेंट को क्या कर दिया था? स्ट्रक डाउन कर दिया था as unconstitutional. The relevant portion of the above mentioned observation made by the Supreme Court is as under. अब वो relevant provision मैं पढ़ रहा हूं जो उन्होंने उस judgment में कोट किया. The observation of the Constitution bench that bona fide need of the landlord will stand very much on the same footing in regard to either class of premises, चाहे वो रेसिडेंशियल हो चाहे नॉन रेसिडेंशियल हो, बी इट शेड्यूल्ड इवन, राइट? आप उसमें अंतर नहीं कर सकते. यू कैन नॉट मेक अ डिफरेंट स्टैंडर्ड ऑल द टाइम, राइट? स्टैंडर्ड सेम रहना चाहिए. ईदर क्लास ऑफ प्रीमाइसेस रेसिडेंशियल और कमर्शियल fully support the view. We have taken that the classification created by the amendment has no reasonable nexus with the object sought to be achieved by the act. We therefore hold that the provisions of the amendment quoted in earlier part of the judgment are violative of article 14. लिंक कर दिया कॉन्स्टिट्यूशन के आर्टिकल 14 से, राइट टू इक्वालिटी, हाँ, इक्वालिटी बिफोर लॉ, ठीक है, ऑफ द कॉन्स्टिट्यूशन ऑफ इंडिया एंड आर लायबल टू बी स्ट्रक डाउन. सो अकॉर्डिंगली द अमेंडमेंट्स वेयर स्ट्रक डाउन. गॉट द एस्पेक्ट. जो डिस्टिंग्विश कर रहा था रेसिडेंशियल और नॉन रेसिडेंशियल के एस्पेक्ट को, उन सारे एस्पेक्ट्स को, उस अमेंडमेंट को क्या किया कोर्ट ने, स्ट्रक डाउन किया. वी अलाउ द अपील, set aside the impugned judgment of the High Court, declare the above said provision of the amendment as constitutionally invalid, and as a consequence restore the original provisions of the act which were operating before coming into force of the amendment. The net result is that a landlord under the act can seek eviction of a tenant from a non-residential building on the ground that he requires it for his own use, the parties to bear their own cost. So that was the result, that was the outcome. हालांकि सरकार ने अमेंडमेंट लाया, but it did not existed. The Honorable Supreme Court ने उसको क्या किया, स्ट्रक डाउन कर दिया. यहां तक मेरे साथ. तो स्ट्रक डाउन करने का इफेक्ट क्या हुआ कि ओरिजिनल जो एक्ट था, एक्ट ऑफ 1949, जिसमें अमेंडमेंट लाया गया था, नाउ इट बिकेम इफेक्टिव. इट बिकेम इफेक्टिव एंड अमेंडमेंट बाय द Honorable Supreme Court order became ineffective. यहां तक मेरे साथ. डन है यहां तक रिया? चलो. Thus, after the said amendment was struck down by the Honorable Supreme Court, the landlord under the said Act of 1949 is free to seek ejectment of the tenant from the demised premises for his own occupation from a residential as well as a commercial building. In case of an ejectment, it's sought by the landlord on the ground of his personal necessity, then although it has been held by various courts that the rent controller shall proceed on a presumption that the requirement of the landlord is bona fide, and that was held in Sarla Ahuja. That was held in Sarla Ahuja. That was held in Sarla Ahuja 1998 RCR and again in 2004. However, this does not mean that ejectment of the tenant is automatic. ये automatic नहीं होता. You have every power. You have every power that you, for your own need, for your own purpose, you can very well get your premises, be it commercial, be it residential, you can very well get it evicted. You can very well ask the tenant to be ejected from the premises. But that does not mean it is automatic. It is not at all automatic, right? And is on mere asking. On the other hand, for seeking the ejectment of a tenant on the said ground, the landlord has to satisfy the conscience of the court. Controller को, court को आपको convince करना होगा. You will have to, आपको बताना पड़ेगा कि yes, you really need it, and the real cause has to be shown, right? And strictly fall under the parameters of section 30 as envisaged under the said act, and prove that his need is more than mere wish and a desire. तो need actual need है, you will have to prove it, right? सिर्फ मेरे मन में आ गया कि अब इसको खाली करा लेना है, इससे मेरे संबंध अच्छे नहीं है, मेरी इज्जत अच्छे से नहीं करता, चल हटा, इस ग्राउंड पे एविक्शन नहीं होगा. यहां तक मेरे साथ. The said situation came to be analyzed before the Honorable Punjab and Haryana High Court in the full bench judgment of Banke Ram versus Srimati Saraswati Devi 77 का judgment है, when it was held as under. To sum up the reply to the question referred for decision is that it is essential for a landlord to plead the ingredients of subclause. Subclause, that is not ये B होना चाहिए. subclause B and C of para 1 of section 13(3)(a) of the act in his eviction application, and that decision of the division bench in Krishna Lal Shetty's case in this regard does not lay down a good law. ठीक है? However, it may also be relevant to point out here that while the full bench clearly held that it's essential for the landlord to plead the ingredients of subclause B and C of section 13(3)(a), it also held in para 12 of its decision that in the present case, we are concerned only with the question as a principle of law. Now, one thing I would like to quote here. The point is, a landlord एक जो क्लियर स्टेटस बन रहा है कि लैंडलॉर्ड कैन ऑलवेज गेट द टेनेंट को जो उसने प्रीमाइस दे रखा है, जो भी प्रीमाइस उसे दे रखा है, जो भी, चाहे वो प्रीमाइस रेसिडेंशियल हो, चाहे वो प्रीमाइस कमर्शियल हो, ठीक है, कमर्शियल हो, उसे खाली कराने के लिए he possesses every right under section 13 of the Rent Restriction Act of 1949, right? Every right he has, but that right must be a bona fide right. Bona fide right कहने का मतलब है, just we mean to say that it should be backed by some sort of reasoning, right? It cannot be vague. It cannot be vague. अब मेरे मन में आ गया कि मैं ये खाली करा लूं प्रीमाइस, इस ग्राउंड पे केवल आप एविक्शन नहीं करा लोगे उससे. मुझे वो बंदा पसंद नहीं आ रहा है, तो ऐसे आपको क्या करना पड़ेगा, उस रीजनिंग से you will have to satisfy the court. You will have to satisfy the court कि yes, you are in real need, चाहे वो पर्सनल ही क्यों ना. If it is personal, then also you will have to satisfy that I really need it, okay, and you will have to put it before the court that yes, I am in real need of it and I want my premises to be evicted, खाली करा दिया जाए, ठीक है. Now that will be checked by the court. A great amount of scrutiny will be done कि is your reasoning valid or not, and then only the court will pass the appropriate order of eviction or not, right? If your reasonings are okay, then only it will be asked to be vacated. Otherwise, he will be the renter, the tenant will be said to be there. Okay, so that is the main gist of this whole of the law, actually, we can say. So there were some judgments. Krishnal Setty's case, full bench bhi baitha, Punjab and Haryana High Court ka, that also we have seen, right? Banki Ram का केस, श्रीमती सारासती देवी 77 का ये जजमेंट है, ठीक है. होल एस्पेक्ट मैंने अभी, ये इंट्रोडक्टरी क्लास था. We will see the rest of the aspect in the next class. Yes.